Dave Gladish is a local attorney. Dave, let's go through it. I want to talk about Jerry Sandusky. Where are we on this thing?
Well, between Jerry Sandusky, we've had the issues with the Catholic Church and all these things. A lot of attorneys have said to themselves, how are they able to bring up crimes from so long ago and these individuals sue for these crimes from so long ago? So what I wanted to do is give a little flavor for what's going on right now with Jerry Sandusky, and then explain to people what the current status of Indiana law is as it relates to these types of crimes. So just to bring everybody up to speed, Jerry Sandusky was a fairly well-known and very prominent coach as it relates to college football at Penn State. I think he was their defensive coordinator, and actually some of the Bears players played under him and had only nice things to say about him as it relates to his skills as a coach. He is currently facing 50 counts of abuse, and he's out on bail on $250,000. He's also being represented by this attorney that I would say the most attorneys are not very respectful of what he's done. He's allowed his client to do two interviews, one telephonically, another one on camera, and both of them went very poorly. The attorney also made a comment recently, like, if you think that he's a molester, call 1-800-REALISTIC. But I guess when you dialed that number, it was actually a gay porn line. So this attorney continues to put his foot in his mouth. He's doing, from my perspective, a bad job of representing his client. They were going to have a preliminary hearing a week ago, and at that preliminary hearing, you would have to call the individuals that were allegedly molested and have them give their version of events. And this is a way, defense attorneys can say this is an opportunity to get some free discovery as to what these individuals are going to say. You can also make the state put on their case, and you can try to develop, a defense as it relates to what the case is. But the prosecution was ready with 11 witnesses, and they were going to go forward. And then they were going to also ask for, after the evidence was presented, an escalation in the bail from $250,000 to $1 million because of the danger they feel that he presents to the community. Well, Jerry Sandusky's attorney decided not to go forward with the hearing, and they are now setting the matter for a jury trial, and the statements are being put forth in the media that he'll do nothing as it relates to a plea. He's going to go forward with the criminal trial, and he'll be vindicated in the end, even though it seems to be a mountain of evidence against him.
Now, let's go back to this. In Pennsylvania, I don't think it's like Indiana, they actually have to show their evidence to the judge, right?
In Indiana, the same thing. You can ask for a preliminary hearing as well and see if there is enough evidence to meet the foundational requirements for the charge being presented. So they had 11 witnesses lined up to say, yes, this man molested me.
And they decided not to do it. And part of the reason may have been that they would have escalated the bail at that time, right?
The prosecutors would have sought that. It still would have been within the judge's discretion. In the United States, we are entitled to bail except in murder charges. And I think crimes involving treason, you're not entitled to bail. But in all other instances, you are entitled to have a hearing at least on the issue of bail. Then the court has to weigh several factors to determine, what kind of danger are you a flight risk, and so forth.
Now, with Sandusky, now you're going to talk about how the laws here are in Indiana.
Correct.
So the laws in Indiana are similar to Pennsylvania's in terms of child molesting?
Well, I'm not going to deal with the child molesting because child molesting, I think most people have an understanding as to what child molesting is. What I want to focus on, which is very interesting, I think, is what is the time period that these charges have to be brought in a criminal context? And then on the other side of that, if you have been wronged through an action like this, what is your time period to bring this type of lawsuit? So there's standards for both. So the first one, and we have another attorney that I know very well, Mars Gonzalez, is on the line. Do you want to pick up Mars?
Yeah, let's see what Mars doing. Hey, Mars, how are you?
Two of my idols in the same room. But I'm spelling that I-B-L-E.
All right.
I didn't hear that.
I want to talk about Sandusky a little bit. And we're talking about the errors that his lawyer made, and one of the most glaring errors, it could be just absolutely fatal, is they let Sandusky go on interviews and make his own statements. And what he did was, he said, this was horseplay. I might have touched the guy, how you smack a guy in the butt, good game, or whatever, or in the shower, you just horseplay. Well, the problem with that is generally there's a rule, as most people would know, that you can't bring in evidence of other pending or old charges of the same type in a criminal case. But an exception to that in a sexual case like this is if you claim it was horseplay or accident, then you then you open the door to intent, and they're going to be able to bring in, let's say if they split the cases up, or I don't know how many trials he has, but they're going to be able to bring in the evidence of each of these alleged acts in each trial.
So wait, he's saying on, and I heard the one with Bob Costas where he was where I was watching it, Marcy, and you can imagine my wife was actually throwing pillows in the air. I can't believe this lawyer's letting him talk, and I'm sure you were probably doing the same thing. But so he says, oh, it was just horseplay. We were wrestling, so they could basically use that against him in the civil trials. Is that what you're saying?
No, in the criminal trials and any trial that he has now, he's opened the door to bring in. Usually, you're going to make a motion. Look, this is just one trial. I don't want, you can't bring in all this evidence of each of these specific events. But when you claim that it was horseplay, or it was accidental, or you didn't, when you say that your intent is at issue, then that's an exception to what we call Rule 404, which says you can't bring in in criminal case you can't bring in outside or other events. And now I think what's happened is you open the floodgates, and they're going to be able to bring in any case that he's tried, they're going to be able to bring in all of these 50 different counts.
Dave Gladish.
It's devastating to his case.
And also, he's also made admissions as it relates to several elements of the crime. He's admitting that he's naked in the shower with a young boy. He's admitted that he touched the boy. So, you touch somebody in a sexual way, just touching them, that's battery in and of itself. And if it's of a sexual nature, that's going to be enough for some of the charges against him as well. So he's made admissions that are fatal for him.